Welcome to US Immigrant Journey, Opportunities and Challenges.
Hello and welcome to US Immigrant Journey, Opportunities and Challenges with attorney Edwin Fogam. With over 25 years of experience in immigration in various areas of law, Edwin brings a wealth of knowledge and a global perspective to his practice. I am your host, Kevin Rosenquist, and today's episode is the truth behind visa denials, what employers and employees need to know. Edwin, welcome back.
Thank you very much, Kevin.
So tell me, what are the most common reasons a foreign worker's visa application is denied?
There are many reasons, but the most important ones I can think of, the preparation of the application itself, not meeting the job requirements, also not defining exactly the positions that the foreign national is being hired for. Sometimes timelines, deadlines that are not met. So it's always very important for the attorney to be involved initially so that those minor issues can be taken care of.
How can employers help to prevent this?
First is they should start the process quite early, get somebody who is knowledgeable about the process and the deadlines and the requirements, especially when it has to do with the job definitions as well as the job requirements.
Okay, that makes sense. And what would you say are some of the misconceptions or things that employers or employees get wrong about visa denials and their consequences?
There are so many misconceptions. After denials, some employers and even employees think that is the end of it. That usually is not the case because you could file motions to reconsider, you could appeal it, and you could even file the application, right? There are administrative review processes that you can use with the administrative appeals units. So that is one big misconception about denials, that it is the end of it. Also, there are other strategies that can be used. Even if a particular class of visa is denied, you could switch or change into another visa category, depending on the status you were in. So you have to look at the whole immigration framework and the strategy that has to be used.
Okay. And we touched on it a little bit there. Can you kind of talk about the options foreign workers have if their application is denied? So like if they get a denial, what should they do first? What should they do after that? How does the process unfold?
Well, that will depend on the type of visa and the status of the employee. But there are a couple of general things that can be done. First of all, you could file a motion to reconsider and reopen within the time period, usually about within 30 days, and the whole application can be reconsidered or reopened depending on why it was denied. Sometimes the denial may be based on the fact that important documents were not submitted or were erroneously submitted. Now, another thing you could do is appeal the whole case. If the denial was based on an error on the part of an appeal, will be in order. So you go, and also there are other strategies. For example, you could even change status and foreign national can go back and reapply based on the same situation. So there are many strategies that can be used after such denials.
So typically when someone gets denied, it's usually they probably went through the process themselves, maybe didn't understand it completely and either like missed or filled out applications or paperwork incorrectly. That's pretty much what you're saying?
Well, yes, that is one. Many times it's due to ignorance of certain facts, procedure, or requirements. Also be technical, based on even when an attorney is involved, based on some misapplication of various provisions. But generally, if the application is well prepared with the assistance of somebody who knows what they are doing, then you stand a pretty good chance to get an approval.
Yeah. If it's a clerical thing or a paperwork thing, then you should be able to fix that and then start the process or reapply or appeal. That makes sense to me. What role does the employer have in this process?
Oh, the employer has a very, very important role. First, they have to be engaged and provide very relevant information to the attorney. They have to communicate with the employee constantly. So it will depend also on the category of visa or the type of visa that is being applied. Generally, especially if the employer is the petitioner. In some rare cases, individuals can apply for visas themselves without employers, right? So, but those are exceptions. But when an employer is involved, then they have to provide the necessary information, tax records, job description. So somebody in the employer's office, in the human resource department, has to be in constant contact with the attorney who communicates with the client. This has to be a very cooperative endeavor, right, to get successful outcome.
Are there ever situations? I'm sure there are, but how many times have you been in seen situations where even if an employee's visa is denied or expired, the employer keeps them on?
Well, rarely some employers do that, but it is quite risky, right? I've seen it could if you don't use the right strategy. In many cases, at the time the employer is applying for a visa, a non-immigrant visa, let's say H-1B, for example, the foreign national may be in something like optional practical training, which is a status that is given to students who want to obtain some practical experience. Now, strategically, you can extend that status. And then even if the visa, the H-1B is denied, you could find a strategy to keep the foreign national employed legally. Very important, because there are fines for hiring foreign nationals who are not authorized to work, right? So any employer who is doing that is taking a risk. Is talk with your attorney and know exactly what you can and what you cannot do.
Are there any other penalties to employers, or is it mostly just money, just fines?
Well, yeah, some it depends. If there are elements of fraud, elements of misrepresentation, actually face some more serious penalties. But generally, if it is just hiring, the I-9 was not properly pursued and so on, it will probably be fines.
Obviously, the H-1B has been in the news a lot since the new administration came in, and there's been a lot of talk about it. Has it been a difficult process for you working with people trying to get an H-1B since that? Has there been a lot with all the changes and all the rhetoric and stuff?
Well, frankly, we are still waiting to see what will happen. But prior to the talk about H-1B being supported, H-1B is the visa that is for specialty workers with probably bachelor's degree or above who can work in technological fields and other fields. It's a very important non-immigrant visa for employers, right? The problem that H-1B had before is that it's a capped type of visa, and you had to be through a lottery for the employer to actually use it. So sometimes employers who really wanted to hire foreign nationals under H-1B could not get them in because they didn't win the lottery, and it's also capped. But I think the trajectory is very positive because it looks like that is going to be a visa that will be encouraged under the new administration. So we are looking at that.
That's good. It's good news. You said it's capped and there's a lottery. Is it based on merit? Is it based on skills and education, or is it truly just a total random lottery?
No, it's not a random lottery. In fact, you have to qualify. You have to be a specialty worker with a bachelor's degree or the equivalent before you even qualify for the lottery. So an employer who is going to petition for an employee as an H-1B worker has to first of all determine that that person qualifies as a specialty worker. A specialty worker is one who has at least a bachelor's degree or the equivalent, who will be working in a specialized position. So it's not just a random lottery.
Okay. And how many are authorized each year?
Well, generally, it was last year, I think it was about 50-something thousand. I'm not very sure because the cap, you see, it moves. And this is what sometimes it is increased. When lots of applicants come in and many employers hanging, it is increased, but there is always a cap on it. Yeah.
Okay, that makes sense. And for employers, how do they have to apply to show that they have a need for someone with an H-1B? How does that work? How does that process work for the employer?
Well, the good thing about H-1B as opposed to permanent level certification for an immigrant is that, yes, you have to show the need, but you don't have to show that there are no other American workers willing and able to work, right? That is the advantage. Once you show that the foreign national is a specialty worker, has the relevant education, and you have the need, and you go through the process of the lottery and you are selected to petition, you probably get it if it's within the cap the cap year, you have the numbers. See, that is very important because unlike permanent level certification for an immigrant, you have to demonstrate that there are no Americans able and willing to do the job by advertising and going through a lengthy, what they call PEM process. So the non-immigrant visa for H-1B is really a good transition for that. And while the foreign national is in H-1B, non-immigrant status, you could start the lengthy labor certification process to enable them become permanent residents. That is migrant visa now.
And how often does someone have to renew an H-1B?
Generally, the 6 years is good for 6 years.
Oh, it's 6 years. Oh, that's pretty good.
So sometimes it is issued for 3 years, sometimes 1 year, renewable every other year, but the max is 6 years. After that, foreign national will have to go back or change this before reapplying another period of time.
As far as denials go, for renewals, if it's a 3-year and they try to renew, is it often that people are denied the renewal after 3 years, or is it typical that they get to renew for another 3 years before they have to change their status or leave?
No, it is usually approved, especially if the foreign national is with the same employer, right?
Yeah.
That had already been met initially. Yes, will only increase the foreign national's experience position. So
make them more valuable.
Sometimes the foreign national can change employers. It is allowed within the parameters of H-1B. That may be the only risky position when, if you're renewing and you have changed employers, you may have to prove certain aspects from the new employer's perspective. A little bit of a challenge. But if it is done properly, it will be seamless because, again, the foreign national has already met the requirement for a specialty worker with a bachelor's degree or the equivalent.
So in the event of a visa denial, what are the possible outcomes for the employee status in the U.S. and how do you help people find the best solution?
Well, yes, that will really depend on the foreign national status prior to the denial, right? For example, let me give you an example. If the foreign national was in optional practical training status after F1 student status, I was working, which they could do that for about 12 months, and for STEM could do that for up to 24 months. If the application was filed within that period when the foreign national was eligible to work, it could be denied within that period, and the effect will just be almost nothing. It's just to refund and transition to the next visa. Or you think of changing status, because you can always change from one legal non-immigrant status to another non-immigrant status without much of a problem. For example, we have had cases where students graduate and they are on our F1 as their optional practical training was going to expire within 12 months. They got into a master's program back into F1 visa. And one master's program, probably an employer hires them and they can now file for H-1B. While they are in H-1B status, which is good for 3 years, the employer can file for permanent labor certification. And before the 2-3 years, they could get their green card. So it all depends on the strategy that is being used.
Are there any preventative measures, preventative strategies, or things employers should consider when hiring foreign nationals to ensure that the applications go smoothly and maybe that they're less likely to face issues down the road?
Yes, definitely. First, before the employer should really vet the qualifications, right? The qualification of the foreign national that they're considering to hire, and also they should also look at the ability to pay, the position that is being offered, the requirements, the legal requirements, so to speak. Now, in addition to that, it's important to start early because there are some deadlines. There are some requirements that certain things that are, for example, I told you about H-1B. If you're thinking of hiring an H-1B non-immigrant specialty worker, you have to start real early and register for the lottery so that by the time you're thinking of submitting your application, the lottery is out and you are qualified to apply for that foreign national. So you start early. Also, it's very important to look at the status, the legal or immigration status of the foreign national. I've seen cases where employers file labor certification for somebody who had been out of status, out of non-immigrant status, only to get the labor certification approved, find out that that person cannot legally adjust their status in the United States because we're already out of status. So those things are very important to.
That would, I would say, be very important. Yeah. All right. Well, thanks for that, Edwin. And thank you for joining us on US Immigrant Journey, Opportunities and Challenges with attorney Edwin Fogam. To connect with Edwin and his team, head to fogamlaw.com, and please like and subscribe to our channel and leave us a review. Edwin, it's always great to see you. Thanks so much for being here.
Thank you very much, Kevin. Hope to see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.